Hello, everyone. I think we are ready to start the second panel in this room, panel A2 on data governance. Thank you very much for being here. My name is Ioana Stupariu. I am a researcher at Central European University in Vienna and Budapest, as well as a teaching associate at Babes-Bolyai University in Romania. I'm also a member of GigaNet. I'm actually a member of the steering committee. I'm the secretary, as some of you may know, may have seen the email with the confirmation of participation and Zoom details from me yesterday and today. I'm very happy to be chairing this session because this is a topic very close to my heart, as my topic of research is actually data regulation. So I was very happy to read the paper submitted to us on this topic. Together with me, we have today a dear friend of mine, Claudio. Claudio Lucena is actually a professor at Paraiba State University and is going to be commenting on the paper submitted today. Thank you very much once again for accepting our invitation. And we also have 4 papers that have been submitted and that will be presented in this panel today. The 4 papers, I will present them briefly, and then of course the speakers will be able to tell more about their research, even better than me. The first speaker that will present today is actually Mr. Wanshu Cong. Mr. Cong, it's a Miss, I'm sorry, Miss Cong, yes. So we have Miss Wanshu Cong, who is a former representative of McGill University in Canada from September, actually with the European University Institute as a Max Weber postdoc fellow. And she's going to present a paper titled From Pandemic Control to Data-Driven Governance, the Case of China, with a very interesting analysis on the China's health code, which draws comparisons with contact tracing apps of Google and Apple. And basically, she's going to argue, or her paper argues that this is in fact more than a contact tracing app. It's actually a technology of population control, a tool for surveillance of the population. It's a very interesting topic, and I look forward to hearing more about it in just a minute. The second paper, which we will have today, is presented by Stephen Weber, coming from UC Berkeley School of Information and Center for Long-Term Cybersecurity. I really hope Stephen is here with us because I know that he has encountered some problems earlier today. I hope that he will be able to make it to present his paper today. If not, you will be able to access the paper on the GigaNet website. The majority of the papers submitted can be accessed on the website, so feel free to scroll through them and read the very interesting analysis. His paper is titled A Data Sharing Discipline, in which he basically argues that we need a new discipline which defines and regulates data sharing by companies. He's basically saying, he's analyzing in his paper the different types of data that we have, trying to explain how each type of data relates to each other and how we can basically have a working model of data regulation, which could function for all potential stakeholders included. He will explain this better than me if he comes. If not, I encourage you to access his paper on the website. Then we will have another paper on data governance coming from Mr. I hope it's a Mr. not a Miss, because apparently I'm not very good at guessing the names based on how they sound. Arindrajit Basu, I saw that you are here, and Amber Sinha, yes, from Center for Internet and Society. My apologies for not being a very good pronouncer of your names. Their paper is titled Conceptualizing Beneficial Interest in the Political Economy of Data, a Theoretical Inquiry. And basically, they have built a blueprint for a proposal to rethink the interest of different stakeholders in data and how their corresponding conflicts of interest can be resolved. Another interesting topic, basically showing that we have different interests at stake, like we have individual privacy as an interest, we have the interest of the state to protect the safety of the citizens, the interest of the companies that of course would like to monetize the data they collect. All these interests have to be resolved somehow. And this is another interesting proposal that we are going to hear more about. And the last paper today is by Stephan Koloßa from Ruhr University Bochum from Germany. I should be able to pronounce this name since it's German, but apologies if I'm mistaken again. The paper is titled "The Disregarded Global Potential of Data Protection Law," in which Mr. Stephan talks about Article 3.2 of the GDPR, the one about territorial scope, and how this definition of territory has been impacted by the recent jurisprudence of the Court of Justice of the EU. And he's also asking whether we need and whether it would be feasible to have a global data protection system in light of the need to have stringent data protection laws across the world. Some very interesting subjects, I believe. And without further ado, I suggest we proceed to the first paper and to have questions and discussion at the end of the presentations. If you have questions for each speaker, please write them on the chat so that at the end we read them aloud and they also have some time to think about your answers. So thank you very much. And we are going to start with the first paper. The first paper by Miss Singh. Yes, sorry again for pronouncing your name and for the honest mistake. And you have the floor. Normally you should be able to share the screen in just a minute.
Okay,
you are now officially
fine.
Yes.
Can you hear me fine? Okay.
We can hear you.
Okay, and then I'll share the screen like this. Okay. So good morning, good afternoon, and good evening, everyone. Thank you to Ioana for the nice introduction. And this is my first GigaNet Symposium, and I'm very delighted to be here. So as Ioana just mentioned, so my paper is essentially a case study about this smartphone app called a Health Code, which is used in China since early February to deal with the COVID. So it's a very country-specific and time-specific case study, and I hope through this case study you can still generate some synergies with other with my co-panelists. So here is the outline of the paper, and for the sake of time, I'll skip the first point and jump directly to the functionality and technical specificity of the health code. So basically, the health code is a program that analyzes people's risk levels and assigns people with different colors. So it collects data, it uses data that collects from individuals. So here the picture is basically screenshots of a questionnaire that the user would fill in when registered on the app. And it also collects information from public service. The colors then here correspond to the different levels of virus risk. So from high to relatively high to low. And then orange code, and the orange code would mean that the person needs to be confined for a week, and the red code means the person had to be confined for 2 weeks. Then the colors also change in real time along with the dynamic risk assessment result. So the main technical feature of this health code, as we can see, is that it uses big data analytics rather than, so it's different from contact tracing apps that use Bluetooth technology. So with this health code, it doesn't really tell you if you've had a close contact with someone having the coronavirus, but it calculates the probability of that close contact, and based on which it calculates the general risk level of a person. As we know that this type of probabilistic knowledge is difficult to falsify, especially if we don't know the source of the data, the quality of the data, and the hypothesis of the algorithm. And this is the case for the Chinese health code. So it's not surprising that so far there is no efficacy assessment about the health code. There's no studies about how accuracy it works. Well, to my knowledge at least, and to what extent it really contributes to China's effort of controlling the pandemic. This, of course, then raises many critical questions about the accountability of the algorithm, the legality and legitimacy of forcing people to use it. Of course, the problem of privacy and personal data protection is critical. The question of digital divide is critically important as well. And so these are all related to more general questions about, the data-driven governance and the techno-solutionism as a response to the pandemic. However, in the context of China, so the lack of efficacy proof doesn't really prevent the adoption of the health code in China at a great scale and speed. So just to give you a sense of the scale, so in early March, roughly about a month after its creation, so Tencent published some statistics. So its health code was scanned for more than 1.6 billion times and covering 900 million people. And in mid-May, it was scanned for 9 billion times and covering about 1 billion people. So this, I think, we can't just consider its usefulness in terms of scientific validity or accuracy, but we have to consider really how it is used in practice. So in actual practice, I discussed in my paper, so we can observe that the health code is closely tied to the transformation of regulatory and disciplinary power in various public and private entities. So from schools to companies to residential communities to restaurants to governmental agencies, etc., etc. So the pandemic really only just an entry point. Basically, it's a technology of population control by being imbricated in traditional forms of governance and control. So this is a very vivid example of the so-called technological empowerment, which is a pretty popular narrative in China among policy and the scholarly discussions about digital technologies. But with the case of the health code, we can really see the sort of paternalistic implications of this narrative. So essentially, the health code empowers traditional forms of governance by further mixing mass surveillance and the provision of basic public services. Now comes to the third section of my paper, which discusses the power dynamics of the health code. And I look at these two type of power relationship. With respect to the first one, the public-private partnership, now it's probably a bit cliche to say private technology companies played a significant role in designing digital tools to deal with the pandemic, as we often talk about the big tech colonization of public or social infrastructure. In the case of China, the health code was initially designed by Alibaba and Tencent. In fact, these two companies were approached by the local government in Shenzhen and Hangzhou to design an app that helped the cities to manage returning workers. And soon, and then the app got traction elsewhere. So not only did these two companies lead the technological development of the health code, they were also heavily involved in the standard setting process of the health code at both local and national levels. Here's just a table that shows you that Alibaba and Tencent were among the drafting teams for 3 national standards for the health code, which were released in mid-April. So obviously, the two private commercial platforms are exercising significant regulatory powers by both effectively regulating people's activities and by engaging in policy and lawmaking processes. With respect to the central and local relationship, it's actually pretty interesting because very often in discussions about contact tracing apps, the health code was often mentioned in either news or studies as the contact tracing app most widely used in China. In fact, in the paper, I argued that this statement is not quite accurate because in China, you don't see, there's not just one single health code, but many health codes based on respective jurisdictions. And this kind of proliferation of the health code is actually a result of the central-local relationship. So while the central government set the overarching objectives and the strategy of pandemic control, it was the local government who then decide whether and how they want to use digital technologies and what technologies they actually want to use. So as I mentioned earlier, the health code was initially a city-led experimentation by which the local governments collaborated with private companies and so got introduced in other cities and provinces, which were basically competing with each other to install whatever technologies at hand to put the pandemic under control. In this initial process of introducing the health code throughout the country, the central government was essentially very much hands-off. The local-led experimentation on the health code was actually created a pretty messy picture. So because different locales had different levels of health emergency, different quantity and quality of data, different methodology of risk assessment, the health codes of different locales were only valid within their own jurisdiction. So it was again the local governments who started signing agreements with each other to recognize their health codes among themselves. So starting from mid-March, the central government designed 3 mechanisms for cross-region recognition of the health code. But even till now, China hasn't really achieved a nationally uniform health code system, especially due to the difficulties of having a deeper and larger scale of data sharing across different departments and levels of the government. So to sum up, with respect to the power dynamics surrounding the health code, we can observe a very strong level of experimental and entrepreneurial spirit of the local authorities, which then converge with the interests of private technology companies. Then central government had largely a hands-off attitude, and then when it wanted to intervene, it was actually quite difficult to catch up with actual practice. This is also reflected by the way in which the local governments keep pushing to expand the health code's functionality and continue using it after the pandemic in China. What's now notably missing in this whole story about the health code is indeed the law. So the out of sync between law and technology is made particularly striking in the case of the health code. However, there are some important signs of law catching up. Most importantly, adoption of China's civil code in May this year, which contains provisions on privacy and personal information protection. And China's personal information protection law is also under deliberation now by the National People's Congress. For now, it's premature, I think, to say what effects these legislative moves would actually produce. My impression is that the frame of privacy and personal data protection, well, it is important, but it also has significant limitations. So in the context of the pandemic, the whole discourse of protection may not only be insufficient to restrain government and private companies who datafy and digitalize people's lives, but actually can reinforce and expand that power, especially by taking advantage by the governments and private companies taking advantage of the public emergencies. So this is a very, very brief description about my paper, and thank you very much for your attention. I look forward to the comments and discussions.
Thank you, Wanshu, for a great presentation. Congratulations for the research, and thank you once again for the insights from what's happening in China. I think it's fantastic to see the developments as we speak in so different parts of the world. They develop in such different ways. I cannot wait for the discussion at the end of the presentations about this. Until then, let's move on to the next paper. I think Stephan has not arrived, so I think we should move to the third paper, right? Stephan is not here, right? I don't see him. So let's move to the third paper, to Arindrajit and Amber. Paper about how to conceptualize beneficial interest in the political economy of data, right? And then, of course, if you have questions for Wanshu or for the colleagues presenting right now, feel free to write them on the chat, and then we will be discussing at the end. Thank you, and enjoy the presentation. You have the floor.
Thanks a lot, and it's a privilege to be part of this session. My name is Sinha, and I'm the Executive Director of the Center for Internet and Society in India. I hope I'm audible to everyone. So our paper is very much a work in progress, but essentially the sort of theoretical challenge that we're trying to address here is about the conception of data. For about a decade now, we've been told that data is the new oil. And in fact, oil is not the only sort of metaphor used to describe data. There are multiple kinds of metaphors that describe data. And at the other end of the spectrum, you have metaphors such as description of data as carbon dioxide or as something radioactive as uranium. But more and more, there seem to be policy documents emerging from different parts of the world that fashion data as an asset. So one of the more recent ones being from India, where there was the idea of community data being put forth. Even in the European Union, I think the more recent policy documents talk about data as an asset and its market value. And while that may be the reality in terms of the emerging reality in terms of policy documents, the commodification of data and personal data particularly has gone on for a fairly long time, right? So the sort of indiscriminate collection of personal data, and then it's used to, and it's sort of tradability for various purposes, and the generation of advertising revenue, which relies largely on the ability of machine learning and other kinds of algorithms to use personal data to profile individuals and then target them with content and advertising and other kinds of information. So the commodification of data is something that has gone on for a fairly long time. And in that sense, what we try to do here is to try to articulate and what are the different kinds of beneficial interests that we can identify for various stakeholders. Because unlike, a fairly proprietarian view of different things, the generation of data itself involves the participation of multiple stakeholders. So the way we have structured this paper is to first look at different conceptions of data itself, and then we try to look at what kind of beneficial interests can different stakeholders, whether it is the individual, the community, private sector, or the government, claim in terms of data, particularly in personal data. So these are the various kinds of conceptions that we felt were the most commonly used to describe data. We start off with data being spoken of as in terms of proprietarian view. So there is a great intuitive value in terms of thinking of data as a proprietarian value, right? So data ownership is something that we've heard for a fairly long time. But the key thing when we try to classify anything as property, then we must be able to think of it in terms of three conditions, right? The first condition is that of possession and enjoyment. The second condition is that of exclusive use, that you might be able to, the ability of the property holder to exclude others from their use of the property as per their wish. And finally, the value of transferability, right? The ability of the property owner to dispose of the property by gift or sale or other forms of transfer of property to someone else who then becomes the owner of that property, right? So in that sense, property is very much an interest in an object, and whether it is tangible or intangible, that must be enforceable against the rest of the world. Now, with regard to data, and particularly personal data, we find while it has been treated like a commodity for a fairly long time, and that it's been treated as commodity essentially enforced through one-sided contracts, where data collectors are able to exercise non-negotiable contracts against data subjects or data principals. But in order to conceive of data as property, it comes in direct conflict with the right to privacy, right? So if we think of privacy as a fundamental and human right, and we try to and the right to privacy often includes within it, in certain jurisdictions like the EU, there is a corollary right to data protection. Whereas in most other common law jurisdictions, the right to privacy includes a positive duty on the state to frame data protection regulation that protects personal data of individuals. So while right to privacy and data protection are not synonymous, there is a very clear sort of connection between the two. And the thing that we must consider is, when we think of data as property, in what ways must it, in what ways does it come in conflict with the right to privacy, or in what ways is it a concept which can be reconciled with the idea of privacy? And there, for data, and particularly personal data, and even in some cases non-personal data, which earlier was personal data, so it could be anonymized data sets also. In those cases, for it to qualify as property, the alienation or alienability of that data must be possible, right? And so alienation in that sense implies transferring the moral authority to engage in the general practice that the right protects. Right? So it's not merely waiver, it's not merely giving up that or extinguishment of that right for particular purposes. It is the ability to actually give away the moral authority in that right. And that, we argue in our paper, is something that comes in direct conflict with the fundamental nature of the right to privacy. And hence, this whole idea of data as property falls flat, because of privacy being an inherently inalienable right. While arguments are made that people are able to trade off privacy on an everyday basis, where we make choices. Privacy essentially involves making choices about how we deal with our data. To fashion data as property, and hence an alienable good, would actually take away the fundamental nature of that right. So it's not just limited to individual decisions being made in a particular situations to allow access to data. It actually would entail transferring the right to control access to data to another entity altogether. So that is primarily why we argue that the conception of data as a property is fundamentally flawed and untenable. My colleague Arindrajit will now come in and speak about the other conceptions of data and how they fit in our analysis.
Thanks, Amber. So, just quickly, I think before going into the conceptions, just to make a point that this paper wasn't, unlike the previous excellent paper that we heard, it wasn't created sort of thinking of one jurisdiction or thinking of one legal system. As the title suggests, it's a very theoretical inquiry that tries to merge concepts across jurisdictions in some sense, and therefore automatically a number of arguments that we make will not apply legally to, a number of jurisdictions if you look strictly at the law. But we do think that, broadly speaking, these are concepts that can be applied in a context-specific manner across most legal and social spectrums. So on to this idea of data as commons. And this is something that we actually got from an excellent paper that was originally presented at GigaNet a couple of years back by Jennifer Skabatur, and that I think remains the best and most holistic conception of a global data commons, so to speak. There have been other papers, including one by Arindrajit that speaks about data as commons, but we think that these two papers make up most of the argumentation on data as commons. So very quickly, what is this idea? Basically, there already exists an idea in personal data protection law, which says that the individual has a right to access their data to find out useful things about themselves. So when you look about a data commons, there is no reason why this can't be extended to other stakeholders as well to, again, find out useful points of analysis about themselves. So that's the broad idea behind a data commons, where essentially people have access to the data that individual or the other stakeholder group has created, right? So in that sense, data commons is not necessarily open data, and it could be, but what Skabatur does in her paper, and I think that's a very useful way of looking at it, is there is a gradation of the kinds of data that might be fully opened up and other kinds of data that may be opened up in limited senses through various other legal or policy means. So that I think is a useful gradation to bear in mind. The other thing that Skabatur does in her paper, which we agree with, is to what forces companies who are data processors, who collect a lot of data, to actually open up the data sets. And that is an age-old public utility doctrine that exists in the US and is also being incorporated into other jurisdictions, where if the two criteria are satisfied, which is something is a natural, or a company has a natural monopoly, and there is a overarching public interest in that utility, there is a compulsion on that company to basically share that public utility. And that we think applies to a number of large technology companies today. So therefore, we feel that data commons is a useful conception in certain cases, and that can be used to identify beneficial interests, which we'll come to later. The second is data as common property resource, and that has been said. I mean, it's I suppose an extension of the argument is data as commons. The only thing I will add here is that as Amber already argued, looking at data as an asset or a resource is flawed, right? Because there are certain inherent rights that individuals have in their data, and that is, it is harmful to the individual's interest to actually look at it as an asset that can be alienated. And therefore, we don't actually agree with this conception of data as a common property resource. Along with data commons, the two which we think are most relevant are data as decisional autonomy, and that has been spoken by a number of scholars, where essentially decisional privacy is the starting point, which essentially is the right against unwanted access or interference in an individual's decisions and action. That is decisional privacy. Now, decisional privacy doesn't necessarily have a direct implication for autonomy, but it could. So in various cases, it's been noted that when decisional privacy is violated, and when there is unwanted interference with that person and that individual's life, often that has an impact on the autonomy that individual enjoys. So for example, if you know that your phone is being tapped right now, it is likely that the autonomy that you engage in conversations with is going to be limited. So there's a lot of excellent research from a feminist lens as well by scholars who have suggested that identity programs or health programs actually lead to the diminishing of women's autonomy in several respects. So therefore, we think that looking at data as decisional autonomy is actually quite a useful framing, because that protects the inherent interests that individuals enjoy across jurisdictions. The next conception is data as sovereignty, and that is basically when you look at the interests of states against other states. So historically, in international law, there's the doctrine of the permanent sovereignty over natural resources that came about sort of in a similar political context, where there was an argument by the global south suggesting that there was this upsurge of colonialism where companies from one part of the world, the global north, were exploiting resources that were created by or rightfully belong to the citizens and states of the global south. And therefore, this articulation simply suggests that states have a certain interest over data that is collected by their citizens, of course, bound by other doctrines such as, I mean, historically, there's the public trust doctrine, which says that you should use your resources in a sustainable manner, in a manner that's beneficial for the public. We think that that's another useful conception to have. The final framing that is not there in this slide, but we actually also look at, is what Amber has already referred to, so I won't spend too much time on it, is community data, which is that in certain cases, there are also rights that a community as a group has over data, which is separate from the rights that the individual has. And while defining the community is a challenge, we feel that that is again a useful conception in a variety of cases. So we actually, in the paper, we look at various kinds of communities. So communities that are self-aware, that is, they self-identify as a community, which could be, for example, a religious group. There are communities that are algorithmically created, where essentially the algorithm determines a set of people to be a community, even though they may not identify as one. And therefore, the rights and implications that these groups may have might be different based on where they are. So we'll quickly run you through the next sort of next last two slides. I know we are already over time by a little bit. So Amber, do you want to just quickly give an explanation of this? Yeah.
If you could finish in just 1-2 minutes, that would be great, so that we
yeah.
have time for the discussion. Thank you.
Yeah, absolutely. Yeah. So Amber, do you want to quickly run through this?
Yes. So I think as far as the state's sovereign rights is something that Arindrajit already covered, so I will not go into that. But what we've tried to do here is we've tried to, this is the beginning and like we said, a blueprint of what the beneficial interests of each stakeholder could look vis-a-vis other stakeholders involved in that. So the individual's beneficial interest, as we argued, we think the conception is that of data as an exercise of decisional autonomy, and that's the way it's exercised against other individuals, it's exercised against the state, community, as well as private platforms. And that decisional autonomy is exercised either through informed consent, or in some cases there is an additional layer of the idea of legitimate interests under the GDPR, which poses further obligations on data controllers to take decisions which are aligned in some senses and cannot be against the benefits of the data subject themselves. State, again, there's a sovereignty aspect which Arindrajit covered, and aside from that, when the state deals with either the community or with private platforms, the public trust doctrine as well as the idea of data commons and public utility comes into place, and then the additional responsibility on the state to sort of frame, to create frameworks where these conceptions can influence how data is shared and data is dealt with.
Awesome. Thanks, Amber. So quickly, just to 30 seconds to end this, rather than going into, I was thinking, rather than to summarize this, rather than going into, again, the recipient of beneficial interest here and the private platform, the basic idea here is that we look at the conception of data, and then we see in a specific context with regard to a specific stakeholder against all of the other stakeholders, what are the beneficial interests that they should be enjoying, right? So if you just look at both this table and the previous table, which are basically the same table in the paper, what we've tried to do here is just explain why each of these stakeholders have certain interests. That interest can actually be conceptualized by looking at the conception of data. And simply that is what we're trying to do. We pick the conception of data that is most appropriate in a certain scenario. We look at the various interests that historically exist with that conception and explore the legal and historical origins of that concept. And then we go into trying to basically setting each interest off against the other stakeholders. So that's what the point of this paper and our proposal is. It's very much a work in progress. So look forward to the discussion. Thanks for hearing us out. Cheers.
Thank you, Amber and Arindrajit for a lovely presentation, very engaging. I think Stephan has not arrived, so I propose to move to the other Stephan of the panel, Mr. Stephan Koloßa from Germany. Stephan, if you are ready, you can start your presentation on the paper on a potential global framework for data protection law. Very much look forward to hearing what your ideas are.
Thank you very much, Ioana. I hope you all can hear me. I try to quickly share my screen and then we are ready to start right away. So yeah, that should work right now. So thank you very much that I have the chance to share some thoughts on data protection law, actually in connection to public international law and public international legal scope. So I am by training a public international lawyer, so I am very much interested in this kind of implications, namely, for example, jurisdiction issues that we have with regard to the global regulation of data flows. And the GDPR, as an example, shows excellently that we do have a potential to have maybe a strict data protection regime, but on the other side, we need to balance those interests, the privacy interests, with other competing interests, namely the ones of the sovereign other states. So what I did is I was analyzing especially 3 judgments of the ECJ, the European Court of Justice, that have come out rather recently, and to analyze the idea of how to balance these interests. So let me start with the general idea that we have right now as a basis for the GDPR. So actually, as a pioneering regime, we have Article 8 here of the EU Charter that sets out personal data protection not only as one certain interest of maybe the economy and the economic effects of global data flows, but actually we have it stipulated as a fundamental right, just right next to the right to privacy. Now, seeing the GDPR, we have the need, of course, to protect the citizens or the EU people, the people that are currently in the EU, to the utmost possible. So then, of course, the courts came to various questions on how far the scope should go, if there should be a global scale or not, if, for example, Google should be obliged to globally put down the names or data or information, so to say, to de-index information on a certain individual on a global level. And so far they have actually denied such a global reach. But if you look closely or more closer to the actual reasoning, you see that there could be bigger potential in regulating that. So looking in general to the public international, one second, like this, onto the public international law scope here. So we're talking especially on the about the jurisdiction to prescribe, actually. So I explicitly do not talk about the jurisdiction to enforce, for example. That is a different question, but actually just to establish the rules for the community. So going with Oxman, I define the jurisdiction to prescribe as something that concerns the allocation of the competence to regulate daily life in between states and other entities. And usually we have this kind of trend that where there used to be this idea that jurisdiction is closely linked to the territory of a state. This has shifted a little bit and opened up a little bit towards the passive personality principle and the effects doctrine. So to say in other regimes, we already have this idea, for example, in antitrust law, that effects do trigger actually the jurisdiction to prescribe of a state to create legal rules, also to situations that happen abroad. So with regards to the internet and the cyberspace, so to say, we have this of core importance because nowadays we do not have this kind of typically territory-based situations any longer, but we share data around the globe, and we have various jurisdictions or classical jurisdictions at stake. Now, if you talk about jurisdiction and about the jurisdiction also in the sense of human rights law, it's important to say that this jurisdiction notion is only the one that is more or less on the common sense on the public international level, because this term or notion of jurisdiction in human rights treaties, for example, is different actually, and more or less means the factual power. And this is actually not so much relevant here, but actually what I mean with jurisdiction here is actually the competence that the state has. And talking about the states at the international level, of course, what comes into play is the, although I want to be careful with the term, but the sovereignty of other states. So the sovereign interests that are at stake that you have to balance in this kind of framework. So data protection law is, so to say, the framework to solve the tension between, first of all, the duty to protect the citizens, and on the other side, the competence that is limited by the other sovereign interests. And if you look at the jurisprudence of the court, there are especially three cases that are important. First of all is the case from 2014, the Google versus Conceptualizing Gonzalez, the Google Spain case, really famous case, of course, on the right to be forgotten. But then we have also other cases that go into the similar direction. Google versus CNIL from 2019, and Klavišnik Piesek versus Facebook Island, also from 2019. And if you look at the reasoning of those decisions, it gives you an interesting idea or potential of how you can interpret Article 3 of the GDPR. I should mention that all these judgments do not interpret directly the territorial scope of the GDPR, because it deals with a previous framework, for example, the Data Protection Directive. But still, also in the Data Protection Directive, you already had potentially global scope. So this idea to have really excessive interpretation here is not completely new. So the Article 3 right now, and more precisely Article 3, Section 2 or Paragraph 2, reads, especially with the application that the regulation applies to the processing of personal data of the subjects who are in the union, so not just citizens, by a controller or processor not established in the union, and then only referring to the offering of goods or services and the monitoring of their behavior. So in general, we see that we do not actually have this territorial nexus any longer for triggering the jurisdiction, although you have the title and the headline which says territorial scope, but actually it does not concern the territory per se, but actually the citizens or the people in the union, which only refers to their protection and the behavior, what they do, and maybe offering goods or services towards them. So it's not directly linked to the territory per se, but rather to the person. So what does that mean actually for the idea of jurisdiction here? First, we're coming from the territoriality principle to the effects doctrine, and what does it mean right now? Are we gonna have soon to be a really large scope, generally territorial jurisdictional nexus that is potentially global by default, so to say? And here it's important to structure the interests a little bit differently from the classical ideas. So first of all, I want to argue that data protection law is not simply a little part of privacy law, but actually, as stipulated in the EU Charter, it's a different human right or fundamental right. So data protection law is the tool to balance also privacy with other interests of third states. So here, for example, in this chart, this balances the sovereign interests and then the right to privacy on the other side. And then the right to be forgotten is a subset of the right to privacy. And on the other side, again, you have freedom of information and other ideas of the ordre public, for example, which need to come into account. And if you look into the reasoning from the court mentions some aspects, for example, the importance of economic aspects and the effect-based jurisdiction. But it merely says then in the end that there is no globally accepted right to be forgotten, and balancing is not globally accepted per se. So there would be no need for global dereferencing or de-indexation competence by the EU. So it lacks a bit of balancing, or put it at the right scope here to have the right interests at stake, especially with regards to the level of protection. So what I want to say now, and in the end, to conclude also with my presentation, the scope of the GDPR should be assessed in a two-step test, so to say. So first, the general application of the GDPR per se, which can be triggered by Article 3 GDPR as such, so to have a really wide scope. And there you do not directly need to maybe interpret this monitoring or offering goods or services in a narrow way. Here, it's possible to interpret it in a wide way, to open up this kind of balancing scheme that the GDPR offers. And as a second step, the concrete interests should be balanced with the concrete obligation in question. So here, Article 17 is the right to be forgotten, for example. And with concrete duties and the concrete obligations in question, there should be put the concrete balancing of the various interests at stake. And if you have this kind of careful balancing where you actually do consider all the different interests at stake, then you can actually have data protection law as a meaningful tool to regulate data flows and to have a more encompassing protection of the right to data protection. So thank you very much, and I hope I am still on the time.
The timing was perfect. Thank you, Stephen, for an interesting presentation. We have 2 questions. I was wondering whether we answer them now and then you proceed with the comments. Claudio, what do you think? Does this work, or we leave them for the end?
I think I have very brief comments. I think we have about 20 minutes left of conversation. I think we could mix the questions I have now with the ones from the audience. They maybe address the same things and give our authors the chance to comment them.
Sounds perfect.
Thank you very much, Ioana. That's a pleasure to see you again, and a pleasure to see many dear friends and colleagues with whom interaction would be much more interesting if we were able to be together now, like Carolina Guerra, Milton, Tracy, Sinue. I've seen them all here. Thank you very much for the invitation and the opportunity of reading such insightful pieces. This is what I'm having here. I'll have one issue for each of you who are present here to comment, and then I think we can mix with the rest of the insights we have from the audience. To start with, a shame and a pity for me that I hadn't known about Ms. Cong's work before. We have in the Data Protection Committee in Brazil just launched a collaborative book, an e-book with pieces from 13 jurisdictions called COVID-19 Global Insights. It addresses different ways in which different jurisdictions fought or found ways to cope with and to deal with this global pandemic situation. And although I'm also a part of FGV's CyberBRICS project in Brazil, we could not be able to reach a fellow with a Chinese perspective, and this perspective is missing. Unfortunately, is missing in our book, and I think that this could be. It's a late contact, but I'm glad to hear and know a little bit more about it. I've seen you mention, just close to the conclusion, you mentioned the draft bill and data protection in China, right? So I believe when you finish the paper, if I'm not mistaken, the draft is very recent. The finished draft that is put forward is very recent, and you probably did not have much time to comment on it to finalize the paper. The issue here is I believe there might be some issues that are issues that are raised now in this, let's say, in this more urgent use of the health codes that should or might be addressed with this new data protection law. You had 1 or 2 minutes to comment on them, and I think this is a very interesting insight because it's a new piece of legislation coming after the period of critical surveillance that was necessary or convenient by the time. And I would like to hear a bit more from you. How does this new data protection framework play into the issues that came up from the COVID situation? From Mr. Basu and Sinha, I like very much hearing about the comparison with the natural resources. I think this comparison with data and natural resources are present in all the papers we've seen here. I'll add that we're, apart from the comparison not being the best one, there is a detail that misses from that, The Economist comparison, that is oil is non-renewable, right? On top of everything, data and oil is non-renewable. So this is a major difference when we're trying to make this analogy between data and a natural resource. I just loved the way you try to pair, the idea of pairing the different interests and trying to see what they have in common and finding the right balance is very, very interesting to me. The final chart is particularly interesting. But I started the day today in the IGF, in the pre-event, with Mr. Axel Voss, Fiona Alexander, and Natalie Pang on the coordination of Konrad Adenauer Foundation. And we were exactly discussing a possible environment for a global data governance scenario, right? And then I would like to hear from you if you have thought, I know it's a blueprint. I know the paper itself is still an ongoing work, and I'm eager to have a version of your papers that is ready for wider sharing, because they are very interesting insights. But I would like to hear from you, how do you envisage that being implemented in a global scale? Because even the relations that you make to build that comparison chart, that pairing, they might not behave the same way in different jurisdictions and in different global scenarios, right? The perspective that you bring from a global south is particularly interesting to me as a Brazilian, because the way to reconceptualize notions of data is very dear to us. This world hasn't been with us here in the global south as it is in the global north for long, and it's a very rich perspective to me. But I would like to know if you have envisaged ways of implementing that on a global scale, and how would you address that asymmetry in the way these things are defined or paired together as you did on a global scale. And to finalize, I would like to also compliment Stephan on a very rich judicial analysis, and also try to make the same inference that I'm bringing everything from the data governance panel from early morning into my discussions of the day. And I would like to know if you mainly address the issue of a global framework from a judicial review, a judicial approach perspective. My question is that the forum or the institution that you see as best equipped to deal with this construction of a global framework, or is it the only one you have to research? And if you envisage this global framework being construed in another framework of institution, alone or together with the judicial review one? Thank you very much once again, Ioana, and thank you, the authors, for such insightful contributions.
Thank you, Claudio, for your comments and for being here with us and sharing from your very recent experience in another panel. Now I'm sorry that I missed that. Sounds like a very interesting discussion, but I'll check the recordings. Okay, so I think now that you have some questions up in the air, I'll give the floor back to the panelists to try to provide some answers, taking into account that we also have some questions from the audience. So maybe if you could check that and provide some answers for those ones as well, that would be great. So maybe 2-3 minutes for each presenter. I think that would be okay. Who should we start with?
Well, I can start since
perfect. Thank you, ladies first. I like that.
So thank you very much to Claudio for the comment. Indeed, like the draft of the Chinese personal information law was released very recently. I actually had a quick look last weekend, and in the paper I sort of talked about how the whole COVID situation and the use of health code sort of provide this kind of motivation at the policy making level to push forward the regulation of data collection and use of personal data. And so in this perspective, then the draft actually is sort of probably a kind of tipping point for the data governance at this thing, the Chinese context. So a lot of, from what I've seen in the draft, from a very quick overview, a lot of provisions were indeed inspired by, for example, the GDPR regarding, for example, rights of data subjects, obligations of data processors. I don't think there is actually a separate category of data controllers, but basically they're all merged into this category of data processors. So a lot of inspirations from GDPR, I think, probably as a sign that the Chinese policy and lawmakers realize you can't just have a sort of a single-centric regulation or governance regime, which is really not just it's just not very instructive. As to what specific sort of COVID legacies that we can observe from the draft, I think there's just a separate clause in the draft that actually provides a specific ground of legal basis for the collection of individual personal information, which I think is actually in Article 13, paragraph 4 of this draft law, which says there's particularly one situation of the legal basis of the collection of personal data, that is when it is necessary to respond to sudden public health incidents or protect a natural person's lives or health or security of their property under emergency conditions. So I think this is a specific, explicit reference actually to the COVID situation. So we can see actually the whole the situation of addressing COVID, and also China was basically put under the spotlight by the international media and the different government, of course. So this we can imagine almost the policy and lawmakers were having that in mind when they're deliberating what sort of legal basis the law would provide for the collection of personal data. So yeah, that's my answer.
Maybe before we move to Arindrajit, who I see is getting ready to answer the question, there's a question specifically for Ms. Kong from the audience about the situation in Wuhan, whether you could talk about a bit the tensions arising in Wuhan when people have been punished for criticizing the Chinese government as a response to the early spread of COVID-19. A question from Professor Milton Müller. Thank you for your contribution, Professor.
Well, it seems to be a more just a general question outside the context of the paper. I mean, well, personally, I just find it was, well, of course, it affects me at the personal level very much when I see sort of the sufferings at the in Wuhan, at the same time, a very sort of collective and very sort of strong response from the Chinese government, and which was very sort of in a rush to actually transform the whole story of initial mismanagement to a sort of victory narrative. And in that also in Wuhan, it's a very topical case where the pandemic is addressed by a high level of digital surveillance in collaboration of man-powered monitoring approaches and technologies. So I don't have much to say about how I really think about that tension. I guess it's just the overall reflection of human suffering and the dissatisfaction of this kind of top-down imposition of governmental reactions that is really sort of just trying to make the whole sort of human suffering into a victorious narrative. Yeah.
Yes, of course. I personally guess that every time there's a restriction of people's freedoms for every reason, be it for national security or for to stop the spread of pandemic, there will be tensions in that society. So I think it's only the natural response. Thank you for your answer. And Arindrajit and Amber and Stephen, now you have the floor. Sorry for intervening.
Yeah, no, thank you. And that was a very important question. So very quickly, thank you, Claudio, for the question. So first of all, that's something that both Amber and I have looked at in a number of separate papers that are actually published. So I can share that separately. But I think on global data governance, independent of this paper, and I'll come to this paper in a bit. But I think the problem is that different countries have fairly different conceptions of where global data governance is supposed to go. And I'm sure that was discussed in the panel as well in the morning, that on the Osaka track, for example, India has been vehemently opposed to it, right? And I think on e-commerce at WTO as well, in terms of that sector, again, India with South Africa have been opposed to a moratorium on that. So on that, it's therefore where we will go on in terms of a global data governance agreement is very much a political question. That's a question we've dealt with separately. We've studied the Indian ecosystem in some detail, and we know that it changes based on who has a greater say in lobbying. So that is very much, I suppose, a political and a diplomatic question, and that is an important one, which we refer to separately. This paper, actually, what we're hoping to do, and maybe we need to sort of tighten things up, is actually maybe start 2 steps before that, as in an like ideal world where of course there are differences in legal situations, there are differences in the policies of various countries, and differences in perceptions also, as you rightly mentioned, Claudio, that for example, firms are treated differently across jurisdictions. But our paper essentially tries to go 2 steps back and put forward certain conceptions which might, at a high level, enable interests to be conceptualized. After that, now how that is implemented is very much dependent on the development of the law and the political ecosystem in each country. And I don't think that our paper, and perhaps the feedback might be that our paper needs to look into that political and legal scenario. But essentially, the ambition with our paper was 2 steps before that, where we simply try and outline theoretically what the interests might be. And we've not really looked at the political question as much, although, I mean, we have separate papers on that which we can share. Amber.
Yeah, I mean, just to add to what Arindrajit said, I think so what we're trying to do here is, in any case, I think some of the, like you mentioned right at the introduction, some of the legal theories and regulatory theories that we're referring to, they're not situated in any one jurisdiction. But what we're trying to do is we're trying to look at established as well as evolving legal theories in common law countries, and looking at some of the directions, assuming the most progressive version of those theories, the direction that they might be taking, and try to conceptually look at how these beneficial interests might arise and might be situated, right? Then the question of convergence, as you speak about, Claudio, even I don't know if a global data protection regulatory regime is possible or not. But if there is a common understanding across countries, and a lot of them have shared sort of legal histories, and institutions have developed around similar lines with marked differences. But if there is a common conceptual understanding of this issue, then it might be possible for there to be some convergence across those jurisdictions also. And that is potentially an extension of this paper that we could look at that point, that what sort of convergence might be possible around this growing idea, and then this idea has resonance across countries. And what we also recognize is that there is definitely a clear power asymmetry that one is dealing with. And that power asymmetry is across individuals and states, it's across individuals and private parties, it's perhaps across states also. So the one part is to recognize that asymmetry and then see that the current system of how data gets commodified needs to be revisited. And if we are able to at least conceptualize those interests, then perhaps from there we can start looking at common language of convergence that different countries could potentially arrive at.
That's great, thank you. We also have a question from you from Ms. Susan Aronson. Whether you think there will be no comprehensive and effective approach to data protection unless firms are required to A, be transparent about how they use our data, and B, there are clear rules regarding who controls the mixing of personal and proprietary data, as in smart cities, apps, and so on and so forth.
Oh, sorry.
Yeah, that was for you.
I missed that. Yeah, sorry, I missed that. Yeah. Sorry, Amber, do you want to take that or?
So let me address point B first, which I think
if you could be quick, because we have 4 minutes left and then we have to wrap up.
Sure. So let me address point B first, and there I think that is something that we make a reference to in our paper in terms of beneficial interests that private parties also have, right? So the mixing of personal data with proprietary information. I think what needs to be looked at is where the intellectual labor of private parties is coming in. And one way to demarcate that is something that we also see in the GDPR itself, where under right to portability, volunteered and observed data is distinct from inferred data, which is seen more within the domain of the private party and not subject to the same privacy rights per se. With regard to the first question, and this is actually something that Arindrajit and I look at in a separate paper on AI, where we try to articulate the idea of what we call retrospective adequation, where we try to circumvent some of the transparency challenges that we face with machine learning, and actually advocate a very simple administrative law principle on how it must be addressed. But I fully agree that these are issues that we need clarity on before this matter can be resolved.
Thank you. And if Stephan and Ms. Kong have something to add or want to answer the same question, they are very much welcome to as well. The question was addressed to everyone, not just to the two colleagues that just presented. And of course, Stephan, you have the floor for your replica to the comments.
Thank you very much. Yeah, let me maybe briefly answer to the question. Thank you very much, Claudio, for the question and excellent comment. Yeah, of course, the courts is maybe not the perfect forum to establish the new law, or maybe to decide upon the new law. Why did I choose the ECJ judgments? Well, because I was focusing on the GDPR, and the ECJ is the most competent revision body in this kind of in this area, actually. So that's why I was taking the jurisprudence of the ECJ. But maybe on a more broader scale, why a judicial body? Well, maybe the states should actually, more easily speaking, the states should maybe agree on a certain limiting their jurisdiction, or maybe limiting their sovereign interests or sovereign competences. But the problem is that right now we don't have this kind of agreement on the international level. So there's a bit difficult to find a common sense here to maybe have a robust framework. So the best idea would maybe not to take the judicial body, but I think it's the most effective way, at least for now, and maybe if we use it in the right manner, maybe the jurisprudence can establish step by step more concise rules on this matter, and maybe put a step forwards, and then we can take it up from there on the international level again, maybe. Thank you.
Thank you, Stephan. If anyone has any final questions or comments for either panelist or for us, that's like the final call before we close up this session. If not, now we are going to take a short break until the next panel. All papers are available on the GigaNet website, and the recordings will also be made available there, as well as probably by the IGF Secretariat, together with the other recordings of this year's IGF. Just as a reminder, after the third panel, so basically in 2 hours, we are going to have a business meeting, which is sort of a chance for everyone to discuss and to get to know each other rather informally, though it's called business meeting. Feel free to join for a less formal discussion on any topic, either what we discussed today, or other topics of relevance for internet governance. And don't forget that the hashtag for the symposium is GigaNet 2020. And that was it. Thank you for being here, and have a great break and a great rest of the conference. And thank you once again for everyone for being here.